Hello and welcome to the Scuttlebutt Podcast. This show exists to uncover the stories and tactics from the world's most interesting veterans at the top of their craft. You're going to finish listening to this episode more informed about unique industries and careers, questions that challenge you both personally and professionally, and specific steps you can join us on as we aim to become more lethal in our life and business every single day. I'm your host, Brock Briggs, and today I'm speaking with Shamus Flynn. Shamus is a former Marine Corps officer and now a partner at Flynn Giudici, a law firm he co-founded where he specializes in small and medium-sized businesses, particularly litigation. Expect to learn how the changing world we live in today on the heels of a global pandemic and the advent of artificial intelligence is influencing our court systems. We discuss the fee structure of law firms, when it's worth it to pursue litigation as a small business, and specific leverage points that you can take into any dispute to find the upper hand of potentially a bad situation. You can find this episode as well as the video version, transcripts, and all other written content to keep learning at scuttlebuttpodcast.co. Please enjoy this conversation with Shamus Flynn. How do you manage a schedule when you're probably working from home in a lot of environments, but you're probably doing a lot of travel for that as well? And then guessing what your work cadence looks like at different points of the year. Is it just impossible to take vacation or time off because it's so kind of case dependent?
So it depends, right? The good thing about working for yourself is you set your own schedule. And so to the extent I want to take time off or go somewhere, I can pretty much do it, right? Now, the only sort of caveat to that is in the law and sort of legal game, but really more so litigation, you are wed to, you have two other parties you're dealing with, right? And so maybe if you're not running a law firm, you're just running a generic business, you have your customers to answer to. On the law firm side, you actually have a few people that you're accountable to, and oftentimes their schedule dictates your schedule. And what I mean by that is this. So if you're on a litigation matter, you have opposing counsel who's got their own sort of calendar and deadlines they're working through. You have the court who has set these deadlines. And so you're working off of those. And then you have your client who your client may owe documents or your client may need to show up to a deposition. And so you're trying to juggle all of that and then chart out what you had just asked, your own sort of cadence and schedule. And it can be very difficult. And so oftentimes there's a lot of sort of maneuvering. Hey, can we get an extension here? Oh, you need an extension? Sure. Take 2 weeks. And then what you're trying to do, like on a personal level, is forecast and look at the calendar and go, when do we notating owe stuff to the court or to the other side? Have we already got an extension? Okay, so no more extensions. Okay, so I can't take off the next 2 weeks, but I probably could at the end of the month take some time off. And I'm pretty good about that. I'm able to work through my calendar. We have a staff of folks too that helps. It's not just me doing this. I have a partner. We have some other lawyers we work with. And so definitely have support. But that's one of the big things that a lot of folks don't like practicing law that are lawyers or lapsed lawyers is you have all these various deadlines and they don't go away. And so they're always on the back of your mind and you're trying to just manage those.
There are a lot of things I'm guessing that help draw out time in court and why that's spent. You just highlighted one of them. How big of a driver or what is the percentage of what you just described as like asking for extensions and things like that? How big of a contributor is that to the overall scheme of why law moves so slowly, do you think?
It's definitely a contributor. It's so to because you touched on it. What happened was pre-COVID in litigation, a lot of lawyers lamented that you would get drug into court and you might have to show up at 8 a.m. on a Thursday. Your case may not be heard till noon or 1. And so you're literally just sitting in court while 15 other people in front of you go. And it was the most inefficient process like known to man, right? And so you might not get back to your office till 3 p.m. Your client, you've had to bill your client for it. And it was just complete time suck, total waste of time. With COVID, what happened is a lot more remote as all businesses went remote. Courts went remote too. And that has really streamlined a lot of things. And so like depositions or court appearances, a lot of them, not all, can be done via Zoom or sort of Microsoft Teams, so remotely. And that has made it so where I don't have to travel to Denver. I don't have to go to Las Vegas for a 30-minute court appearance or maybe a San Francisco for a 4-hour deposition. I can just do that from my home or my office. And so that is definitely, I think that is streamlined, like to bring full circle, the sort of court's caseload. And I think that because they don't have to always go on the bench and the opposing counsel doesn't have to show up for all these things, it has streamlined things a bit. But in terms of like, why does it all move so slowly? You have to remember, especially in state court, these judges have a full calendar and they're hearing most of them, not all, they're hearing civil cases. They may have my civil contract dispute. I just had this happen. They may have my civil contract dispute in the morning. And later that afternoon, they're sentencing someone for armed robbery. And same in federal court too. And so there's like a lot of moving parts. It's not just, hey, I represent a widget company and they're in a fraud dispute with some other company or breach of contract. And you're just sitting there, why won't the judge resolve my case here? You got to remember they're dealing with like very sort of weighty stuff. They're dealing with criminal stuff. The federal judges are dealing with immigration matter, big, heavy constitutional matters. And so all of those sort of forces can weigh on a court's docket and really slow things down. And I think us in the business world go, why isn't this done faster? And these folks oftentimes the courts are on limited staff. They have only sort of finite amount of resources and it can only move so quickly. And a lot of this stuff is very complicated too. You and I, in this nitty gritty, maybe litigation issue, it seems very straight and not complicated to us. But to a court who's got a few hundred cases on the docket, it's the first time they're looking at it. They're like, hey, I need some time to consider this and think about it. And all of those things take time.
So what does the future of law look like in terms of just like a processing standpoint as we're maybe coming out of COVID here? Is it going to be changed forever? Will it have been more streamlined because of this now?
So I think it's going to be streamlined in a lot of ways. So obviously from like a court sort of remote appearance, remote deposition, remote court appearances, remote oral like appellate arguments. Yeah, I think that's going to get streamlined. If we're talking more of what's like artificial intelligence going to do, and is that going to kick in and streamline things? I think it will to an extent, but more so on the transactional side. I think a lot of lawyers who just do like very basic agreements for small to medium sized businesses they're in danger because if it's a pretty narrow issue, you just need like a simple lease done. I think that you're going to be in the next year to 2 years, if you're one of the parties involved in that transaction, you'll be able to quickly find that simple lease online somewhere or ChatGPT or some sort of company that does that. It'll be very low cost. What won't change is just the nature of disputes, right? And people are always going to get in fights with each other. And so there's been some hot water with some litigation lawyers leveraging artificial intelligence to draft up their briefs and go find legal research and case law. And it came back with sort of bogus results, but they didn't really verify it. They submitted it off to a court and they got totally slapped down. It was like very big news in the legal community. And I do think there's going to be guardrails for a lot of this stuff because just like a lot of industries, think doctors, lawyers, there's some protectionism to it too, right? It's like, hey, we want to make sure that it's actually humans doing this stuff. But technology for sure has shaped the way the law game goes, whether it be transactional side or litigation, from discovery and taking in vast amount of documents, digesting them. Technology for sure, and especially if you know how to use it, can be a huge sort of bonus.
How are you using some of the tools today in your business? Just out of curiosity.
So I don't use artificial intelligence because I think that my clients are paying me for what I would call bespoke drafting. They're not paying me for generic positions. I know some people use it for like basic background research, but at this point, I don't think it's fine-tuned enough to be able to rely on that. So I don't use it at all. So that's the artificial intelligence in terms of I don't have it go find me research or answer basic questions. Like I can go do that on my own. And then I draft the documents all on my own for good reason. With respect to like, how do we use technology? We use technology a lot, right? We have various programs to help just a law firm run, just like the database management system to track billing and what's coming in the firm and what's going out, clients matter, stuff like that. We use Google Suite a lot, right? We use the cloud-based system from Google. We're using Google Docs. We're using Google Sheets, right? so that folks can collaborate, whether it be on some sort of Google sheet, because we've got a list of discovery and we're trying to organize it, or it's a Google Doc and we're drafting a brief and I got 4 people in it and everybody's opining on that. But that's not abnormal. I think a lot of companies are doing that. A lot of firms are doing that. I think that we do a pretty good job of integrating technology into our firm.
Do you want to take maybe 2 to 3 minutes and give me a high level overview of your background and what ends you up here today sitting in front of me?
Yeah, yeah. So I grew up in Southern California and I went to college in the Bay Area and I graduated 2008, 2009. And it was right at the sort of financial crisis, global financial crisis. And I was a finance major. Like a lot of folks, I was, hey, it's probably not a great time to get in the marketplace. And I've seen the writing on the wall starting in '07, turning the calendar to '08. And at the time, I think I needed some discipline and structure in my life. And having grown up in Southern California and not far from Camp Pendleton, where the Marine Corps base is, I said, maybe I can go in as an officer. One of my cousins was an officer in the Marine Corps. And so reached out to an officer recruiter, started the process when I was still in college, and it took about a year. And by the time I graduated in 2009, I had been selected to go to Quantico. And so I went off to Quantico, was there for a year. It was commissioned, and then got sent down to Camp Lejeune, did some more training at Camp Lejeune. And then I checked into my unit in Lejeune and was told very quickly that I was being farmed out to a small team to go to Afghanistan. And that really kicked off this incredible sort of 18-month period in my life. We did a 6-month workup in Camp Lejeune. We did a month out in 29 Palms out in the desert. And then I went to Afghanistan for a year, 2011 to 2012. And came back. I was in Afghanistan. I unfortunately got injured pretty badly about halfway through. I was blown up by a suicide bomb via car. SV bid is what they're called. And I recovered. I went to Qatar, had surgery, and I just didn't want to come out of the fight. Drank the Marine Corps Kool-Aid back then. And I fought my way to get back in Afghanistan, got back in. I should not have gone back. I just wasn't healed. And I finished out the tour there. And so at the 12-month mark, went back to Camp Lejeune. And I was at a crossroads of what I wanted to do. Did I want to stay in? I had another sort of almost year left. Did I want to get out? And I just was not in love with the area, North Carolina. And when my 10 came up, I decided to get out. And I understood that I had the GI Bill at my disposal. And long story short, ended up going to law school on the GI Bill down in Florida, finished law school, did another year up at NYU studying tax. And after that, went to the Bay Area, took a job doing mergers and acquisitions, doing big tech mergers and acquisitions for PwC. And when I was there, I actually was given the opportunity to go clerk for a Ninth Circuit judge, which really was just like this incredible once in a lifetime opportunity. So I left PwC to go clerk for Judge Rawlinson on the Ninth Circuit, finished that clerkship after a year in Las Vegas, and went back to the Bay Area to go work for a large law firm, Baker Botts. And then when I was at Baker Botts, COVID hit, and my wife and I were living in San Francisco. It was like another crossroads. What do I want to do? And so I started talking to an old law school friend of mine, and he was transitioning out of a job, and it just seemed like a right time for maybe me to go off on my own. And the target was to go help smaller, medium-sized companies grapple with business issues, whether it be starting up or disputes, or given the fact that my partner and I both have a tax background, helping them out with tax issues. And long story short, we started Flynn Giudici January of 2021. So it's been about 2.5 years. And along that sort of ride, we opened a separate firm, which does government affairs and lobbying. And we've been at it 2.5 years now. And it's a challenge every day, but I wouldn't trade it.
That's super interesting. Is it like basically the end game of most lawyers to start their own firm? Is that kind of like the pinnacle of you've gone through the whole arch and that's like end state?
I think if you ask jokingly, what's the end state for most lawyers, it'd say to be stop practicing law somewhere else. I think, look, most lawyers have a couple of routes. One is you're at a bigger firm and you what's called parachute out to a smaller firm. Usually you get better lifestyle, less pressure, and obviously you make less money, but it's a sort of better lifestyle fit. There's other folks that leave law firms and go what's called in-house, right? They go work for a company and they practice in-house. My wife is in-house counsel, right? So you're working for the company itself. You're no longer affiliated with the law firm. Your clients are your coworkers, HR, sales, ops, right? You're in the nitty-gritty. Then there's people that just stay at a law firm, right? Because they just like being at the structure of a law firm, and whether it be big or small, and they like working with 5, 7, 15 other people. And then there's this other bucket, which is, and it's a pretty big bucket. It's people like me that say, look, I'm going to still practice law, but I want to do it on my own terms. And maybe I'll go off solo, or maybe I'll go off with another partner or 5 other partners. So there's a number of different routes you can go. But for me, it was simply, I just was like, I think it's a good time to go off on my own and give this a shot. So look, 2.5 years later, I'm still doing it.
That's a good sign that you're on the right track and
Yeah.
doing some of the right things. When it comes to practicing law yourself and setting up your own small business, is there any kind of power law or something that you see that dictates how big it's possible to get? Is it a whole bunch of just really small ones and then there's a couple really big ones? Or is there like a pretty wide distribution of sizes when it comes to
The best way to start a law firm is the 180 degree of what we did. The best way to start a law firm is to be at a law firm and go off with a few partners and take clients with you that are going to, so when starting day one, you've already got like a baseline of clients. I didn't have that opportunity. I left a very large firm. These companies and these people that are at the larger firm, that they want a larger firm and they want to pay for it. They don't want to go to a small law firm. And so we started from scratch, from nothing. And so for us, we've gone through different, what would success look like? And you just slowly start getting clients, but it takes a while, right? It takes a lot of hard work, reaching out to people, networking. And I think, as I've told you before, in the legal game, we're constrained in a lot of ways. We're not like a traditional business where I can pick up the phone and go cold call people and say, hey, hire my law firm. I know you run a warehouse, or I know you run a manufacturing plant. You need a lawyer. Let me tell you why you need a lawyer. Okay, you like this? Let me send you an engagement letter. It doesn't work like that. We're out there fighting with one hand tied behind our back because of ethical rules. So we really have to sit on our hands and wait for people to contact us. Now, there's ways you can increase your sort of visibility so that they find you, but it really does take a lot of work. As a result, it takes time, right? It's not one of those, you go out, you have 0 clients, and within 60 days, you're rocking and rolling. It's very methodical and it's really accretive, right? It happens slowly. And then you look back in 6 months and go, oh, wow, we have a lot more revenue in month 8 than we did month 3. And month 18 is a lot more than month 10, but it doesn't happen overnight. That's for sure.
Can you like maybe take a couple minutes and break out the fee structure of what you guys do? Do you target, is it retainer clients or is it one-off work? And then how did that play into how long it took you guys to maybe get to a self-sustaining model where it's paying the bills and you're maybe able actually to draw money from the business?
Sure. So on the law firm side, with respect to billing, we do some flat rate stuff. There's some clients that hire us for a monthly fee, and we basically are doing ongoing work. We know how much work it is. We priced it in. We understand we're charging them a flat rate, and that the economics work out for both sides because we understand how much time it's going to take us. There's other smaller matters, I'd say, or even medium-sized matters where we can prognosticate like what it's going to cost. And this is mostly all on the transactional side. Okay. You got a small deal you need done. We can do it for a flat rate because we know how much time it's going to take. On the sort of controversy litigation side, we bill by the hour. The reason is it's really hard to do a flat rate in litigation because you can really lose yourself. Because I've been in litigation matters or disputes where if I would have charged a flat rate, you think it's going to last 2 months, and then this thing's going on. You're on month 14 now. And so you'd really get crushed if you were doing it a flat rate. And oftentimes in litigation, it almost always takes longer to wind up and either settle or get a judgment than everybody anticipates. And most, I'm sure there's some law. I know criminal defense lawyers, they'll charge a flat rate, but that's sort of bread and butter. They know a DUI and how much time it's going to take. So yes, it's litigation, but they know like that process. Whereas if I get a contract dispute between company X versus company Y, I don't know. Nobody knows these parties. We don't know the issues till we get under the hood. This is not like a DUI or some sort of basic criminal offense where you're like, oh, I've done 50 of these. I know exactly how long this takes. The law is the same. It doesn't change. This is, you got to go through emails and there's the discovery process, there's motion fights, and the fee structure on the litigation is by the hour. With respect to retainers, we always do, unless they've been referred to us by someone that we know and trust, we always do a one-time retainer with a client we've never worked with, just because we haven't worked. I always tell them, we haven't worked with you, you haven't worked with us. There's got to be some sort of trust earned there. And so we'll ask for a retainer. How much? It just depends on what we think, how involved the matter is going to be. And like I tell people, look, the money goes into a trust account. We don't touch it until we earn the fees. And oftentimes, and it happens pretty often, is they'll give us a retainer and we're able to shepherd the matter through in a quicker sort of way. And then they end up getting some of the retainer back because we didn't bill it all. And so there's a lot of firms out there that will do either small retainers or no retainers. They're usually a larger firm that can withstand that risk. And then there's some firms that are very aggressive with retainers and they'll say, look, not only do I need an initial retainer, I want a monthly, what's called evergreen retainer, where you're just replenishing it because they basically just don't trust that you'll pay them. And so we're like a hybrid. We do a one-time retainer. We rarely do a second one just because I think we set the tone from the beginning.
When it comes to, you said that you started off and you didn't bring any clients with you. So you're basically starting from scratch. What did that initial first 6 months to a year look like in terms of, did you have an idea of, at X amount of clients, we will be bringing home this much, or is everything so variable it's really hard to gauge and you just need to kind of take on all projects at once?
It was, look, you take on what you're comfortable with and what you feel you have competency for. If someone walked in with a criminal matter, and they definitely did in the first year, we just weren't taking it. Yeah, would we like the client? Sure, but we just don't do criminal law. If someone came in with a family law dispute and was, hey, can you handle my divorce? There's some lawyers that'd be like, hey, I'll take it. We just don't do family law. So as tough as that is to turn them away, we were looking at, hey, we're business focused. It's going to take time. And what happens is we never had a metric that said, this is when we'll make it. It's like a lot of things. You get in growth mode, especially when you start at zero, everything is growth, right? Everything's growth when you're at zero. Now, when you hit year 2, you could go back and go, now you can start bouncing off of, well, what did we do in May of last year? And what did we do in June of last year? And you can start to compare. The hard part about that is it is variable. I don't know who's going to call me this week and say, I have a big case that's going to go on for 6 months to a year. They could. I may not get that call for another 4 months. I have no idea. Like, you can't predict. It's very hard to predict who's coming in the door with, I don't know who's going to cut a deal that's like, hey, I need a lawyer to draft a deal for us where we need it done in 2 weeks. I could get busy 1 month. I could be slow 1 month. That's one of the hardest parts, is trying to almost like land the plane with respect to revenue and stuff when you're running a law firm, because you just don't know who's going to walk in the door. It's very hard to tell.
You were just talking about how everything from zero is considered growth. I think that's an interesting statement because it does feel good probably to see, oh, we've got work coming in. How do you keep yourself on track when you're guiding against that zero starting point? Because I could see how it'd be easy to get going in one direction and you're taking on clients, money's coming in the door. And I think that this is a problem a lot of entrepreneurs have.
Sure.
When you're starting out, you're like, oh yeah, like I'll do that. And then next thing you know, you're like, why am I taking these people on when this is not actually what I want to be doing? So how did you think about staying true to like what your initial focus is and not veering outside of that, even if it's means money coming in the door?
So That's what I was saying earlier is the first 12 months, you have no baseline. So everything is growth. So if you open in January, what you do in June that year or November, you don't really have anything to compare it against other than to be like, hey, in November, we did more than we did in June. But that's not a great sort of guide because the seasons change. And so what I do is now I'm year two, I can look back to, I've got 28 months of data. And now I can start to compare what did we do last March, right? How much did we do or how many cases do we have? And that is what I can go, oh, you know what? We're lagging. Like we actually did more last March than we did this March. We need to get this sort of, what's the problem? What's going on? And sometimes it's literally out of your control. Sometimes we are slammed for 4 months and we need help. And then there's 2 months where we're like, we're really slow right now. And that kind of tracks the ebb and flow, especially on litigation, because litigation is, if you're on the plaintiff side, you're going to be filing a lawsuit. It's ramp up, file a lawsuit, and then sit around while you wait for the other side to respond or you're trying to serve them. On the defense side, it's the first time you're hearing about it typically is someone got hit with a lawsuit. So you ramp up, then you respond and push it off to the other side. So now you're like in a 30-day peak and valley. And so what happens is if some of those cases are stacked together, that's what can make June really busy and a July is really busy. And then all of those are tethered together on the same sort of stream. And then your August, September might be very slow because you're like, there was a lot of work in June and July. And now those cases are in an ebb right now. And so now that's when we get back to, we try to do when we're busy, but especially when we're not busy, some of the business development stuff. Are we writing blogs? Are we attending events? Are we engaged on social media? Stuff like that. And you try to do those when you're not as busy and you have time, because when you get busy, it's very difficult to do some of that stuff. And to stay consistent, it's really hard, right?
Big time. Yeah, it's difficult to keep those little things. It's not like that they take that much time, but when you're probably working 12, 15-hour days when you're like really ramping, writing that blog post or committing to that once a week social media thing is probably not as high of a priority when that's cutting into the amount of sleep that you're getting.
Totally. Yep.
You said that you try to focus on working with small and medium businesses, and that's like where your specialty arose. Why is that your sweet spot? And why do you care about serving that audience specifically?
So it's a sweet spot because I understand, having worked at a large firm, I know the dynamics of a large company. Large companies are institutional and they're risk averse by nature, and they have boards of directors to answer to. So when they have a legal matter, they'll shop it to a large firm because they know that large firm, they've used them for 2, 5, 10, 20 years, and they know the sort of level they're going to get. They know the players involved there. And as a small firm, getting hired by a large company is very difficult, right? Because they don't know you, they don't trust you. And honestly, there's only a number of these sort of large companies that are using even maybe a smallish firm. So now you're just back into the sort of real world, which is there's lots of small, medium-sized companies, right? And so their issues they still have legal issues. They're just on a sort of more minor scale. So their breach of contract might be over $800,000 dispute, whereas a large company may have a few $100 million, maybe $1 billion breach of contract dispute. And the small and medium-sized businesses, they thrive, as everybody knows, like they make the country hum along. And as a result, there's a ton of legal work there. And they need legal representation. They just don't maybe need it in the same robust capacity that a large firm provides to a large company. They need more sort of triaged work, which is to say, I don't need you all the time, but I might need you like 2 or 3 times a year. And it's just almost a numbers game. There's just a lot more fish when you're talking about the small, medium-sized companies than there are large companies. From a competition, we'd be wasting resources trying to grab these larger companies because the competition is just firms that are like not adjacent to us. They're much larger firms with massive staffs. And it's just something that we just don't spend a lot of time going after.
Do you work to try to differentiate your service to even like a more specific customer group than just small and medium businesses? Because as you said, that's still a very big pond of that's 75% of the businesses in
Sure.
the country is probably meets that category. Is there a way that you segment down further, or is it maybe by more specific issue?
Yeah.
That so maybe not necessarily, oh, we work with service businesses. It's actually the problems that the SMBs are having.
It's usually the problems. And sometimes, I think you and I have spoken about this. If it's a dispute, I'll ask them, what's the sort of nature of the dispute, right? How big's your company? Because
Mm,
if somebody tells me and I'm just throwing this out as an example. If someone tells me their revenue is 400 grand for the last year and they're in a $40,000 contract dispute, I'll be honest with them. I'll be like, I don't honestly, we're probably not the right law firm for you. And in fact, you probably don't even need a lawyer. You could probably do this between the parties. You're a pretty small company. You have a pretty small dispute. And do you want to spend litigation fees on this? Is this like the best sort of use of your resources? So I can often get a sense of how big the company is. I'll say how many employees are there, what's the nature of the dispute, and then that sort of shapes in my mind, hey, is this a good sort of thing for this company? I obviously can't make their economic decisions for them, but I try to be as transparent and honest as possible. I have calls all the time where I tell people this dispute is either too small or it's not worth hiring our firm to do because we'll be mired in this pretty small conflict between two parties with one's a private individual, one's a very small company, and we'll just get bogged down in this. And it's just not a great sort of use. And so we pass on matters where we could probably take in some clients on these very small stuff, but we try to preserve our resources to folks that are a little bit larger companies. And I say large, it's not even that large at all, but there's just a lot of smallish companies, service companies out there that have legitimate disputes, but should find a more streamlined sort of way to do this. Maybe it's going to mediation and you just show up, you don't have a lawyer, it's a $30,000 contract dispute because you can quickly burn through that in attorney's fees. And I try to counsel folks like, hey, this is not the best, likely not the best use of your sort of resources.
You've said that pre-litigation work and trying to mediate this situation so that it doesn't go to litigation is something that you actually specialize in. Do you want to maybe talk through how
Yeah.
you approach that? How maybe let's imagine that you're coaching me, a small business owner, as to looking out for times to avoid. How should I be trying to handle that situation and give me like a little coaching on what that might look like?
So pre-litigation is an art. It's definitely not a science. And it goes back to some of the precepts I just gave you, which is if someone hires me and it's, hey, we're in this sort of fight, nobody's filed suit yet, and this is on the plaintiff or defendant side, you're looking at, hey, what's the size of your company? How big what are your sort of, do you have the resources for this dispute? And then I start looking at the dispute itself. And then if I'm on the defense side, I may say, look, they've got you dead to rights here, right? I'll just go back to the classic. You breached the contract. That's pretty much clear, but maybe you have some leverage. Let's think about your leverage points. Maybe you're the commercial tenant and the landlord's really pinched for cash. So yes, you're in breach here, but you have some leverage here because they really need your cash. Maybe it's a big sort of institutional landlord that it's not doing very well. And so there's some room there to cut a deal. And so you're trying to find the leverage points on both sides. And a lot of times it's counseling the client to be like, look, you may want to just pay these people off. Let's say you're on the defense side. You may just want to pay them off because it's going to be a lot cheaper to do that than to go through litigation. Once we get into litigation, it's combat, right? And these things they are not pleasant and it gets very expensive. And so some of it is looking at your client's company and the situation, and then you're looking at the nature of the conflict. And then it's really counseling and kind of like coaching your client to be like, look, I know you're very aggressive. Maybe you think you want to fight this. Let me explain to you what's going to happen. The judge is going to slap this around, or you're going to be mired in this for the next 2 years. But sometimes it just goes, look, you've breached. If you want to fight this out of principle, or maybe you can't set the sort of precedent in the industry that you'll fold and that you just need to pay these people off. So you want to fight this and go to litigation? Let's do it. And there's some clients that are like, I can't settle for myriad reasons, right? I can't settle. So yeah, can you drag this on for a little bit? Can you help me fight this off? That's on the defense side. The plaintiff side, it's a little bit more, hey, are you ready to rock and roll? Do you have the funds ready? Do you have the facts ready? We've looked at the issue. Here's what it's going to look like. You're going to file suit. Are you ready to end this relationship with the other side? Because that's what happens, right? If you're a company that wants to sue another company, let's talk about the dynamics of that other company. Do you do a lot of business with them? Oh, yeah, I do a ton of business with them. Do you understand that when we file a lawsuit, you can pretty much consider that relationship done? Are you fine with that? Oh, I thought it would just get their attention. Most people don't look at a lawsuit as just getting attention. Some people do. Some big companies go, hey, it's the nature of the game. Yeah, they're a vendor of ours. They sue us. They always sue us. We settle on it. No hard feelings. But you have to be able to explain. There's a lot of folks that have never been in litigation before, and they don't understand the sort of human dynamic of it too, which is this person you've been on the other side with, you guys are fighting in an email. What happens when you sue them and you name them as an individual? Now they've been put on a lawsuit. Are you prepared for it? Are you ready for that? And some people go, yeah, I mean, very litigious folks. They go, absolutely. I've been sued. I'll sue them. No problem at all. It's just a part of doing business. And other people take pause and go, you know what? Let's see if we can make an offer here. I know I'm owed $100,000 or $500,000. If I can get them to make me some payment, maybe it'll be better than rushing off and filing a lawsuit against them. There's a lot of dynamics that go into it. There's some lawyers out there that don't take this position. They'll hear the facts. They'll say, give me the retainer. I'm going to draft up a complaint. We'll file suit. We'll deal with all this later. The problem is, I think you're setting your client up for not for success, right? Because you can completely rip apart a relationship. And as lawyers, for the most part, we don't know the dynamics. And maybe we just filed suit against our client's biggest customer, and it could backfire against the client. Did anybody think about this beforehand? And so a lot of it is counseling, coaching, but at the end of the day, some of these things don't get resolved, unfortunately, unless you you typically file a lawsuit. And the reason is there's a lot of folks out there, a lot of companies out there that basically say, look, I breached it, or I'm not paying you the money I owe you. You can kick rocks, no settlement. I'm not doing anything. I'm not giving you a dime back. And the only way to get them to come to the table is to file a lawsuit to initiate litigation. And when that happens, and it happens frequently, we snap into gear, whether it's obviously filing a lawsuit, or if we're on the other end of it and we get a lawsuit, we sort of war game all the things I just spoke about. And we go, look, do we want to play nice? Do we want to reach out to them, see if we can work a deal? Or do you want to fight this thing and dig in your heels? So the dynamics change, but I do think I'm a firm believer in things can be hashed out pre-litigation if the parties want to do a deal. There's always a deal to be had. Unfortunately, some parties either just hate each other so much, or they're taking a sort of principled stance, which is, look, we'd love to cut a deal, but maybe the insurance company says we can't do it, or maybe our board says we can't sign off on this for now. And there's so much jockeying that goes in, so much decision making. And oftentimes they kick us out of the room because these are economic decisions that I can't drive for them. And I make that comment a lot. I tell clients, both plaintiff and defendant, I don't know like your sort of burn rate. I don't know, do you have a big sort of account or receivable that's going to hit? Maybe you're cash strapped for the next 6 months. So I could show you the path, but at the end of the day, to slap the table on some of this stuff, like, you have to drive that decision. It can't be me.
One of the things that you said early on in that really great breakdown of how to think about this pre-litigation phase is thinking about the strategic points of leverage that each party may have, whether you're on the plaintiff side or the defendant side, and potentially even thinking about what the other party might use against you in that. Are there places that you would encourage people to look? Like, what are those strategic points of leverage? Is it cash is always like a really good one, but what are the other things that people may not think about, but can be used to help bring about a better outcome for themselves?
I mean, that's a good question. It's a tough one because every case has different players involved and the companies are different. And so the leverage points are different, but obviously cash. If you are owed a bunch of money and you want to bring a suit against someone. So then the question is like, hey, I want to file suit. They owe us a bunch of money. What's your leverage? We do owe them a bunch of shipments here in the next month or so. And we could really put a thorn in their side here and disrupt that whole operation. Okay, let's think about that. Are they relying on you for something, or is it just they owe you a bunch of money and they'll never see you again? And that's totally fine with them. Because then you start to think about, we'll ask people, are the folks involved, are they independently wealthy? That oftentimes is a massive driver. What I mean by that is, hey, if you're going after an individual or maybe a small company and a CEO, if they're independently wealthy, you can expect them to go out, hire a robust legal team, dig their heels in and be in a fight. And so maybe your sort of settlement demands, potential offers are shaped by that because you know that this person has a lot of leverage and power. Maybe it's a bunch of partners and they're all fighting and we say, look, there's a mess. Let's just drag them into court and make them fight with each other about it. Every situation is different. And so when you talk about the leverage, literally it all depends. It just depends on it depends on the sort of economics in terms of the time too. Is it, or are we still, if I'm running a restaurant closed because of COVID, is it open now? Is the landlord cash strapped? Is there a deal to be had here from a commercial tenant? Looking at the contracts, all of these things help shape the leverage play there and strategy.
Is there any rules of thumb that you think about? And obviously, as you said, every situation is very case specific and probably not one that applies to everything, but how you think about when it's right to go to court or litigation
Sure.
over something. Is there a dollar figure, or thinking about how much somebody's going to be out versus what
Sure.
potentially the legal fees might be? How do you
Yeah.
weigh those?
My general rule of thumb is if the nature of the dispute is less than like $50,000 or $40,000, I try to counsel people, you don't want to be rushing off the court for this dispute, $50,000 or less. Because now you start in a lot of jurisdictions, you start to get towards $15,000, $20,000, you're in small claims court. And at that point, now, don't get me wrong, $50,000 owed to someone or company, that's a lot of money. I'm not trying to minimize it. But just from if you're a very small company and someone owes you $40,000, it is a lot of money. And you should do everything in your sort of power to get that back. Hiring a lawyer who maybe you can get that done for 5 to 8 grand. And if you can, then it's a win. The problem is oftentimes you can't get it done for that amount. So now you just threw 5, 10 grand at the issue. So now you're out 60 grand and you still haven't got your money back because now you got to take them into litigation. You got to spend another 20. Now you're starting to go, did I just spend 50 grand to potentially get my 50 grand back? And by the way, this went on for 2 years. And now when you get anything over $50,000, $75,000, $100,000, then it goes, okay, it makes sense to put some pressure on them. Maybe it's via demand letter, but oftentimes through a lawsuit. Someone owes you 100 grand, litigation, maybe you have to spend 20 grand to go track down the 100. You know what? It was worth it. So my sort of rule of thumb is I look at that $50,000 mark, and anything under that, it's ironic. It's typically the people that are disputing that are bigger companies, and it's out of principle and they don't care. They're just fighting the fight because they have to. And the fees, or excuse me, the nature of the dispute, 30 grand, 40 grand, you and I would say, look, we're not going to throw legal fees at this. They will, because it's a sort of principle matter.
What informs that $50,000 mark? Is that kind of roughly what it might cost to bring a case, and maybe factors in 3 to 6 months worth of paying a lawyer? What are the figures?
So when I say $50,000, that's the nature of the dispute itself. So someone calls me and goes, hey, I did landscaping work or X amount, or I produced a product and gave it to a client. I sent them an invoice and they owe me $45,000. They won't pay it. That's what I mean. The $50,000, the nature of the dispute. $45,000. So that, I'm not saying that's what legal fees are going to be. I'm saying the nature of the dispute is, hey, they were supposed to pay us last month 70 grand. They didn't make the payment. They're not making it. So now you're talking, the controversy is a $70,000 controversy.
No, I see what you're saying, but what I'm saying is there's something that probably informs that $50,000 mark, because if it cost $5,000 to litigate it, everybody would do it.
Yeah,
of course,
yeah.
if it's 5,000, but so there must be some price that it's going to cost just in fees where it becomes not worth it.
Because I can tell you right out of the gate, just to even get the demand letter out and do all this stuff, you're talking $2,500 to $5,000, right? So now you're going, and then everybody wants predictable results. So they're okay. So you'll send the demand letter out, and then they'll make a payment, right, of the $50,000 they owe us. It's no. They may not respond at all. They may respond and say, "Sure, we'll play ball. We'll give you half that," or they'll say, "Kick rocks." They'll respond and say, "You can come sue us." You don't know. And so that the uncertainty is what's hard. People go, okay, it's a risk thing. It's like I'm owed $40,000, right? I'm going to spend $5,000 right now in legal fees. I might get some of the 50 grand back, but there's a very good chance that I have to file a lawsuit. Okay, now I'm going to throw another 5-10 grand at it. So now I'm 10 to 15 in legal fees. And maybe in 12 months, maybe we can persuade a court that I'm right, they're wrong, and I can get some of that 50 back. But that is like totally not like predictable. It's actually unpredictable because there's so many factors. And that's the part where people go, so you're telling me I'm going to spend 15 grand trying to chase down this 50, and I probably won't have resolution for the next 12 to 24 months. You go, I mean, is it worth it? That's when people start to go, is it worth it? But when you start talking about 75,000, 100,000, $300,000 dispute, $500,000. It's just, okay, someone owes me $500,000. I'm going to be in the fight for 12 to 24 months. And if we can get a smaller payment, that's okay too. But I have to spend legal fees on this, right?
So that is the situation that you just described, is when you are maybe owed that money. And that kind of is a good litmus test of when to call you to get involved, get a lawyer, and potentially look at going to court for it. What about on the other side? When is it time to call you? When maybe you are receiving something in the mail that says, hey, this person has got you're receiving the demand letter. When is it time to get a lawyer or call you and get involved?
I think a lot of the same sort of concepts apply if you're on the defense side. But on the defense, it could be thornier too, because you may say, look, it's only a $40,000 dispute. What should I do? Should I pay it? Should I not pay it? You can do stuff like basically call their bluff. Just say, hey, don't pay it. We'll see if they file suit against you. If they file suit, you could just write them a check after the lawsuit's filed, right? And it's a game of chicken a little bit more on the defense side, right? It's what are they going to do? Are they going to actually file suit over a $33,000 tab that I owe them? If they do, you know what? Maybe I'll make them sweat this out and prosecute it for the next year. And then I'll try to get them to come and play ball. It depends on the dynamic and stuff, but a lot of the same concepts are the same. You're looking at the other side going, where's the leverage? Do I have any over them? Do I have benefit of time? Does the other side really need this money? If so, maybe I can get a great deal on this. I know they're really cash strapped. I owe them 40 grand, but they're so cash strapped, they don't want to litigate this. I can cut them a check for 20 and get out of this. So I just saved myself 20 grand on a bill that I owe. Same concepts though. You're looking at it going, anything less than that $50,000, we'll chat with folks, and then we just go, look, it either makes sense because maybe you're a bigger company or sort of wealthy individual, and it means a lot to you to either defend or prosecute against this. But that's just, and by that is just my sort of rule of thumb. That is not like an industry thing. That's just a way for us to flesh through cases we want to jump on or not. Because as you can appreciate, we get a lot of calls where, hey, someone owes me $7 grand. It's like that's small claims. Like you should not be hiring a lawyer for a $7,000 dispute. Now you and I go, if someone owes you $7 grand, that's a legitimate, it's a good amount of money. But when you're talking about filing a lawsuit over it, it's inconsequential.
Can you maybe walk through the timeline of the steps that need to be taken if you're on the defense side, if you're receiving this demand letter, and then if a lawsuit gets filed, what people could expect if we're going to receive something like that, and how to play this chicken, as you call it, intentionally?
So if you get a demand letter, and let's say you gave it to me on the very first day that you received it, typically a demand letter, they'll give you 15 to 30 days to fix the issue. And by fix, it means pay us our money or stop doing something. Hey, stop building here. You violated this. Fix this now. Cease and desist. Your options are, one, go back to them and say, you know what, you're right. I'm going to fix this. Or you're right. I owe you money. I'm going to pay it. The relationship means a lot. I'm going to pay it. Two, it's to respond and say, here's where I disagree. I'm not going to do any of this. You're dead wrong and you can see you in court. Or three, it's just to do nothing and just basically play a game of chicken and just say, look, don't respond. If they want to file a lawsuit, they will. Sometimes responding riles up the other side and it can enrage them. And so sometimes the best is just to let it cool off. And if they want to file a lawsuit, when that party files the lawsuit, it's completely unpredictable. Obviously, there's statute of limitations on certain things, but some of the statute of limitations would be like 4 years. So like maybe you got a demand letter in February of this year, and the person said, you owe me 200 grand. And if you don't pay it, I'm going to seek legal recourse or I'm going to file a lawsuit. And you do nothing. They give you till March 1st and you just do nothing. Unfortunately, you want some certainty on the defense. You're like, oh, so are they going to file a lawsuit or not? You're like, you don't know. You didn't respond and we don't know what they're doing. They could sit on their hands for 12 months, 18 months, 24 months. Maybe they're behind the scenes trying to get funds together for it. And then boom, they hit you with a lawsuit. If you want certainty and you want to work through it, you respond to them. If you're just, look, they file a lawsuit, I'll deal with it. Then you can just do nothing and wait on them to make the first move. So unfortunately, though, you don't know when they're going to make that move. It's their timeline, not yours.
So there's not any way for you to know if you've received this demand letter. Like it could be a couple months later or even years later, and they could follow up on something like that.
Yeah, they send you the letter. You don't respond. By the way, we've done that. We do that on the plaintiff side. We send a letter out. Hey, you need to respond and pay us by March 1st. They don't respond. Then the client goes, okay, let me think about some stuff. Because now they're starting to think about, okay, litigation is going to cost as much. Maybe I got a big deal coming in next month. I don't have time for litigation. So they come back to you in July, August. Okay, I'm ready to go. September, I'm ready to go. I'm ready to file that action that I told them I was going to come after them for February, March. And then we go, okay, let's draft it. Boom, file off the lawsuit. It just depends.
Have there been any cases that you've taken on since starting your business that have really taught you a lot, or maybe would teach other small business owners a lot?
So they all teach you something different, right? Because we were talking about earlier, the sort of facts and circumstances of all these are different. I think the biggest thing that I've learned is there's always a deal to be had, right? There's always a deal to be had. So whether you owe someone money or someone owes you money, let's just take those two instances. If someone owes you money, if you're not dealing with a good faith person on the other side, and this is the hard part for people to understand when they're a plaintiff and they're owed money, they'll say, I'm owed $100,000, $500,000. And the other side will say, I'll give you 50% of that. And people have a hard time conceptualizing that on the plaintiff side. They're like, I can't believe this. I'm owed 200 grand or 500 grand. And they're only going to give me half. There's a lot of people that operate like that on the other side. This is their leverage. They stiff people on payments. They delay payments. They withhold payments. That's part of their almost standard operating procedure as a company. We have some very famous people in our country. That's how they operate. Right? I won't get into names, but this is what they do. And so I try to explain that to people because there's a lot of people that are just literally in shock. They're like, they owe us this money. Why aren't they paying us? They're on the other side going, all right, we owe them $100,000, $500,000. They're a smaller company on the other side. We've got a bunch of lawyers. Make them come chase us down. Oh, they want to file a lawsuit? We'll defend against it. We'll jam it up in court for 3 years. And that's their way of sticking it to the sort of little guy. And that's just how they operate. So what happens is plaintiffs will go, so what do I do? There's a deal to be had, but you're going to take a 50% discount or 25% discount. And so people, and I get it, psychologically, they're like, I just don't understand like how I'm literally going to get paid like 30% less. And it's, you could file a lawsuit and we could do this for the next 2 years. 2 years. And they're like, I need the money now. Then now you're playing a game with them. You're going to take a 30%. And the other side understands that. They go, yeah, exactly. We're going to get a 30% basically discount on this because you, plaintiff, don't have the sort of energy or resources to hang in this fight for 2 years. We do. You definitely see that.
You said that the psychological effects of that are difficult to grasp. And I agree. I think that if I were in one of those positions, that would be extremely difficult to manage. Do you think that's right? Why is it that way? And should it be that way?
No, it's not right. And again, we can talk offline, but this happens massive companies. It's happening right now. The very famous company where they're basically stiffing past employees, they're stiffing landlords. And by the way, it's all part of a strategy, which is to say, we're big, we're strong, we have leverage. We don't care about our reputation right now. We're happy to get into a sort of legal fight with you and be litigious and wear you down. It's honestly, it's not right, but it happens. And it happens on the smaller level too, the more micro level, where everybody's got a leverage play, right? And so you're just trying to figure out who's got leverage, who doesn't. Whereas some larger companies, so I guess the rejoinder would be, why don't all large companies operate like this? Some of them are more morally scrupulous than others, but some of them go, look, we know that when we're engaged in all these fights, if we do this to everybody, then it would be too cumbersome for us. Employee morale would be terrible because we'd just be like, what's going on with the work this week? Oh, we got 18 lawsuits because we just stiffed every vendor we have. We don't pay anyone. So you can only do it up to an extent. But some people are very strategic in the sort of conflicts and battles they choose. And so they'll do it. And it happens like in a very public way. And it happens in small, medium-sized businesses too. It's not right. The remedy is go to court then. If you think you're owed 300 grand in my scenario or 500 grand, and you don't want to take a discount, go litigate it in court. You can spend the money and probably get a judgment against them. It may take you 2 years. You may have spent 50 grand to 75 grand. And that's the calculus that a lot of people go, I can't be in this fight for 2 years. I may not even be at this company in 2 years, or I don't have the resources to fight this for the next year. I don't have the emotional stamina because litigation is a brawl. And so I don't have the emotional stamina to stay in this fight for 2.5 years. So I'll give it, they can pay us at a discount. So that's what happens, unfortunately.
It's such a bummer because
Yeah.
as you said, that there are some very high profile things like that are happening right now. And you hate to see the value accrue to people who are bullying others they've got the bigger hand, but
Sure.
man, I hate to think I like the idea of a free market. And I think that in large part, our courts are directionally doing the right thing, but seeing stuff like that, it's not super promising. I don't think that I can get behind that way of doing business. And I don't know how hopefully you stick around, but I don't know how you don't walk away with a ton of enemies when you
No,
operate
yeah.
that way.
The other thing is the reason it doesn't happen, it's a good thing. It doesn't happen on a massive scale. To be the person on the other side, the sort of very litigious person, you have to be cut a different way. You have to have the sort of capacity to just be pretty ruthless. And there are some people that get into a litigation matter and they're like, I never want to be involved in this again in my life. I got deposed. It was 8 hours and they were basically down my throat and all the documents I've had, it just completely disrupted my life. That's how most people are. There are other people, and it's a small sect of people that are completely comfortable with it. I get deposed like once a month. I get sued once a month. It's part of their business plan. They're working in legal teams where they just go, look, we get sued a lot. It is what it is. It's just how we operate. And there's a lot of people that have made a ton of money by being very litigious, fighting, stiffing them, stiffing you. They'll make enemies, but like they've made money doing it and they've been successful. But it does take a different person and company to stay in the fight that often and be very comfortable swimming in that lane because it is, for the most part, a very uncomfortable experience for most folks. And so I think that's a good thing. There's not a lot of people out there that can operate like that, but there are some people and they are very comfortable being in litigation. Those are the ones you got to be mindful of.
Be careful who you do business with. Sounds
Mhm.
like a good lesson there.
It's a very good lesson. Yep.
At the beginning of this conversation, you talked about AI stepping into the legal world here and some of the ramifications
Sure.
of that. What are the other interesting things that are happening in the legal world today in your mind?
I think AI is the biggest one because that could conceivably change a lot of the sort of basic transactional documents, maybe some of the basic trust and estate stuff. I think the sort of remoteness that we've gone into is going to be interesting. It used to be that a law firm was judged, especially the bigger ones, by like their office spread, right? I remember when I was at a large firm before COVID hit, my firm was investing millions of dollars to redo our whole floor of our San Francisco office space. And they had just redone it like 2 or 3 years prior. But it was like, hey, we got to keep up with sort of Joneses here. We got to keep throwing money at this because that was a big deal, bringing clients into the office. And now you're starting to see this sort of like more digital remote attorney that's, look, don't waste your time coming into my office that I may not even have. We have an office, we have a couple offices, but there's a lot of law firms that have just done away, gone completely remote. And so being able to reach out and touch people and lawyers without having to drive into a big stuffy office, I think that's been like a big change because the legal game is very anachronistic. It's very old school. And think of it almost like banking too, right? Like you used to be like you had to go in and deal with your bank teller. When was the last time you dealt with a bank teller? You try not to, right? At all. And so I think people were getting into more of a sort of disaggregated, like physical environment where it's just, hey, I meet you over the phone, Zoom, I send you documents, you draft stuff for me. That's our relationship. I'm working, I'm in Spain, I'm in Alaska, it doesn't matter. We can get this done. It used to be like, no, we'll wait till you get back from Spain, back from Alaska. We'll sit in our conference room for 3 hours and we'll talk about your issue. And then you'll come back next week. That's just so inefficient.
Do you think that taking the time and working to meet people in person, if you do that primarily, is that going to be a differentiator for you going
I
forward?
think it is. We have an office up in Northern Nevada that I get up to frequently. Meeting people in person, I like working remotely, but meeting people in person is always a good thing. Honestly, I'm one of these people, I think I'm probably better in person than I am maybe over the phone or something like that. And just things seem to go smoother in person. So I think like on balance, yeah, it's better. Candidly, I wouldn't even mind being in an office 4 days a week, but it's just like employees don't want that. It's not the most efficient. And so I think that there's a sweet spot though between human interaction, but also giving people the space to work remotely. Maybe it's childcare, maybe it's taking care of a significant other or parent or something like that. And I just think the days where you make everybody schlep in 5 days a week and be in there 12 hours a day is like a non-starter now.
For a lot of people, it is.
Yeah.
I know that I'm one of them.
Yeah, no, totally.
If we were to take away one major thing from you that would maybe we could take and implement in our life or business from you today, what do you think that that would be?
When it comes to like my sort of work stuff,
Yeah, work, life, anything.
so I pride myself on responsiveness in terms of if someone wants to get a hold of me, I'm going to get a hold of them very quickly. Right. And maybe that's to my detriment in terms of setting boundaries and stuff. But for the most part, if people are, especially on the client side, people are paying me money, I'm in the service business, right? I'm providing a service. I don't offer a product or I'm not shipping any tangible goods or any IP. So we're in the service business. So like to the extent someone wants me or needs to get a hold of me, like I make myself available like quickly. And I wish I try to give white glove service. And I wish we got that like on the rest of our life for stuff we pay for, just everyday stuff. If you have an issue, if you're paying someone $50 a month for some service or 100, that you'd be able to get someone on the phone. And as you just can't do that. And so I do pride myself on being responsive and available, to be totally honest with you.
I think some of the most high caliber people that I've interacted with have unbelievably quick response times.
Yeah.
Some people you can't pay them to get back to you in a reasonable
Yeah.
amount of time. And I think that in itself is you don't necessarily have to be glued to everything and responding at all hours of the night, but being able to respond quickly, even if it's a, hey, I'm going to give you a better response in X amount of time,
Sure.
just sets
Yep.
really good expectations. And it doesn't take a lot to set yourself apart, both personally and professionally by doing that.
Totally. Yeah. No, I agree. Definitely agree.
What is it that myself and or the listeners can do for you? I really appreciate your time and I'm grateful for you coming on and chatting with me today.
Yeah, look, go to our website. You can take a look at us. You can read about me, a little bit more about my background, my partner's background, and a little bit about our firm. And you can sift through and look to the extent you've got some legal issues, your listeners have legal issues, or they're running a company, they've got some sort of conflict or controversy. especially if they're on the West Coast, Arizona, Nevada, California, or dealing with someone in Arizona, Nevada, California. Give us a call. We could chat about potential ways we can navigate and help bring some sort of resolution or bring the parties together.
That sounds good. I definitely will keep that in mind. You got a lot of business owners that are in and around this show that I'm sure would benefit from your service. So I appreciate that. Shamus, this has been really good. I appreciate your time. Thank you so much.
Absolutely.
Thanks so much for tuning in today. Your listenership helps me better educate people like you and the rest of our nation's military, both past and present, on building a successful life outside of military service. If you're looking for more ways the top vets are leading more effective lifestyles, building businesses, and using the resources designed specifically for you, press here for a selection of some of the best clips. Be sure to like this video and subscribe to the channel to stay up to date, and I will be talking with you soon.